So we welcome you, Shailesh bhai, to this gathering. So topic allotted to Shailesh bhai is summons, search, and seizure under the GST law. Sir, we are thankful to you for accepting our invitation, and today you are here to actually address our participants. Thanks a lot for saying. Let me introduce briefly Shailesh bhai. Shailesh bhai, he is advocate. Yeah, he is practicing in the name of SPS Legal. He is BCom LLB. He has 35 years experience in consulting, advisory and litigation practice in the field of indirect tax laws that includes central excise, service tax, customs, state VAT law, CST and GST. Shailesh bhai has dealt extensively in the areas of central excise, service tax, customs, GST and VAT across the entire trade industry and industry spectrum consisting of manufacturing, service sector, and distributive trade representing diverse sectors. He is regular faculty at various professional bodies as well as trade and industry forums on his chosen field. He has already delivered more than 120 lectures since April 2017 on GST alone. So that speaks loud about him. So he is regular columnist in Vyapar, Gujarati bi-weekly newspaper of Janmabhoomi Group, and also in the midday Gujarati edition on service tax, central excise, and GST. He has been awarded a special award for appreciation in 2019 by Pen and Stationery Association of India, and also by Indian Textile Accessories and Manufacturing Association, ITEMA. Besides professional bodies like Chamber, AITP, he is also associated with many trade bodies, including Indian Merchant Chamber, ITEMA, IDMA, BSE Brokers Forum, Builders Association of India, Bruhad Mumbai Developers Association, and other bodies guiding them in the field of indirect tax, including GST. With this brief introduction, let me invite Shailesh bhai, and I will request you all to welcome Shailesh bhai with loud applause. Thank you. Shailesh bhai, over to you. Ketan bhai, you want to?
No. I think we are all eager to listen to Shailesh bhai. Shailesh bhai, please go ahead, sir.
Thank you.
Shailesh bhai, you have a presentation? PPT?
No. All of you can see me properly?
Yes, Shailesh bhai, yes.
Yes, sir.
We can see you.
Yes, sir. Okay. And am I audible?
Yes,
Yes.
Shailesh bhai, absolutely
Okay,
clear.
right. Thank you very much. Yes. Thank you, Atul bhai, for your kind and words. It's always a pleasure to be amongst the Chamber's professional brothers and sisters. And thank you for this opportunity to share my thoughts on extremely serious and sensitive topic of search, seizure, and summons under GST law. Friends, we are in the 5th year of GST, and now probably all the dark sides of the GST are slowly coming out, becoming visible to all. I'm afraid to say that I would not like to, be a doomsdayer. But if anybody has thought that they have seen worst of GST in last 5 years, I'm afraid they might prove to be wrong, because the real drama will start now. And actually it has already started, if I'm not mistaken. It has already started. Audit, investigation by different authorities, jurisdictional authorities, anti-evasion, preventive, DGGI, simultaneous investigation by different authorities. This is now becoming the order of the day. And the taxpayer as well as the tax professionals are at a loss to understand what is to be done under these circumstances. And there, the importance of today's topic comes. I will concentrate only on 3 parts: the summons, search and seizure. Considering the time constraint as well as the topic as has been finalized, I would not dwell into the subsequent part of confiscation or arrest, and because they are subject by themselves. Friends, in every tax legislation, the powers are vested in the officers department to summon a person and tender or record his evidence in a given case when the officer is inquiring or officer is actually has initiated an inquiry or investigation in some matter. These powers are not being first time looked into the GST. They have been part of even income tax, they have been part of the VAT legislations, and they have been always a part of excise under Section 14, as well as made applicable to service tax by Finance Act 1994. And it is there under Section 108 of the Customs Act. So what is important to note here, that the powers of summons, power to summon under Section 70 of the Cgst Act is not something which is new, number one. And secondly, it is substantially worded in the same manner as were under Section 14 of the Erstwhile Central Excise Act. So first of all, we'll have to get rid of referring to this entire gamut of statutory provisions and the summons related procedure in a very, very different, with a different mindset or eyesight. I am saying this because certain established principles of law which have been laid down, by the various judicial pronouncements in the erstwhile regime of central excise or service tax, or even in the context of Customs Act, and I would go to the extent of saying that even under Income Tax Act, those principles will equally hold good when we are dealing with certain situation arising as a result of the issue of the summons under Section 70 and the subsequent proceedings undertaken there. So we should not really get, become oblivious to the past. In fact, I'm very strongly of the view that the past is only going to dictate the future of GST. Certain celebrity judicial pronouncements on various aspects and the principles laid down therein will continue to have its sway, will continue to have its bearing on more or less similar situations or dispute arising under GST. Before I now proceed, let me confess, generally I try to give my PPT in advance, though I'm not very comfortable with the presentation, but I've been preparing my PowerPoint presentation of late regularly due to some constraints, and I've not been keeping well since last 3-4 days. It's difficult. So bear with me, but I will be sending my complete PPT on the today's topic to the office bearers, our committee, CTC, which they will arrange to circulate to everybody. Coming to summons, the powers of summons are given under Section 70, and Section 70 reads like this. It says, the proper officer under this Act shall have power to summon any person, mark the word any person, whose attendance he considers necessary, either to give evidence or to produce document or any other thing in any inquiry in the same manner as provided in the case of a civil court under the provisions of the Code of Civil Procedure 1908. Subsection 2 of Section 76 says, every such inquiry referred to in subsection 1 shall be deemed to be judicial proceeding within the meaning of Section 193 and Section 228 of the Indian Penal Code. Certain important features come out of these provisions, which are more or less a pattern on the erstwhile Section 14, as I'm saying, of the Central Excise Act. And just for the better understanding, what did Section 14 of the Central Excise Act says as far as the powers of summons are concerned? Section 14 said that any central excise officer duly empowered by the central government in this behalf shall have the power to summon any person whose attendance he considers necessary, either to give evidence or to produce a document or any other thing in any inquiry which such officer is making for any purposes of this act. Then there is a further part which I will come to later on. Section 14(1) of Central Excise Act is much more elaborate, but this opening part, the first sentence of Section 14(1) and the Section 70 of the CGST Act are similar, as you must have noticed. And Section 14 was made applicable to service tax by Section 83 of the Finance Act 1994 also. So they are all on the same pedestal. The other relevant section for the purpose of the today's discussion will be Section 2, subsection 25, the definition of the commissioner in the board. Section 2, subsection 91, which defines the term proper officer. Section 6, subsection 2, clause B, which deals with the parallel proceedings on the same subject matter by two different authorities, that is state government authorities and the CGST authorities. Then there are certain circulars which are also relevant. FAQ on GST, where board has extensively dealt with the how the summons and the subsequent proceedings should be carried on. That FAQ is dated 15 December 2018. Then there are two circulars. Apart from the appointment of the powers, the first circular is 5/7/2017. Other two circulars are the 5/11/2019 and 23rd December 2019. Sorry. Now, the first important thing to be noted here is there are two aspects of this entire procedure. The one is, as I was making the reference about the difference between Section 70 and Section 14 of the Erstwhile Central Excise Act. Section 14, subsection 1, which I just now read out the part of it, also further says a summons to produce documents or other things may be for the production of certain specified documents or things, or for the production of all documents or things of a certain description in the possession of or under the control of the person summoned. This entire part is missing under Section 70 of the CGST Act. However, the board in its FAQ has adopted this particular part of Section 14(1) and said that in issuing the summons, the officer can also direct the person concerned to produce documents or other things or specify documents which he thinks is under possession. So that part has been adopted by the board by way of a FAQ, though it is not part of Section 70. Basically, it amplifies and it actually explains the overall scope of the powers under summons. State मालूम पेश क्यों देता है?
તમારું સામે જ છે. તમે અહીંયા બોલો.
Okay, fine. I'll continue. Sorry. The other important part is about Section 14, subsection 2, and this is important. Section 14, subsection 2 also contained a proviso whereby certain exemptions were granted to which, from the appearing under the summons. These provisions were granted under Section 132 and 133 of the Code of Civil Procedure, and it says that those persons who are specified under Section 132 and 133 of the CTC, Civil Procedure Code, shall be applicable insofar as the requisitioning or attendance under section the summons power is concerned. Now, if you see section 70 only does not even mention about such specific exemption. Section 132 or section 133 of the CTC, which provides an exemption to certain class of people, certain people specified therein, who cannot be requisitioned for the summons purpose. They are conspicuous by its absence. These provisions are conspicuous by their absence in section 70. Incidentally, section 108 of the Customs Act only spoke about section 132 of the CPC. Now, section 132 of the specific CPC, the heading, it reads like this: exemption of certain women from personal appearance. Women who, according to the customs and manners of the country, ought not to be compelled to appear in public, who ought not to be compelled to appear in public, shall be exempt from personal appearance in the court. These are CPC. Nothing herein contained shall be deemed to exempt such women from arrest in execution of civil process in any case in which the arrest of woman is not prohibited by any code. Now, this section 132, which grants sort of an exemption to women from appearing in the court, was actually contained in section 14 of Central Excise Act, but not under section 70 of the Cgst Act. There is no mention about this. Second, section 133 of the CPC, which is the heading reads exemption of other persons. The following persons shall be entitled to exemption from personal appearance in court, namely President of India, Vice President of India, Speaker of the House, Minister of the Union, etc. All the mighty personalities, political and other constitutional authorities have been exempted so far as the appearance in the court is concerned. This was also specifically covered under section 14 of the Central Excise Act. However, both the reference to section 132 and 133 is clearly missing in section 70 of the Cgst Act. Does that mean that a Speaker of the House or a Vice President of India or even Honorable President of India can be summoned by an officer? The answer would obviously be, it would be too absurd, and the answer would obviously be no. I feel this is a bad drafting, but the Code of Civil Procedure Code and the exemption granted therein shall prevail, and therefore that exemption may continue. As far as section 132 is concerned, where the exemption is given to the women on the basis of the customs with a limited, with a restriction thereon. This is one aspect. Probably, I don't know why both the sections are not finding mention under section 70. Going forward, what is summons? There is a lot of misapprehension and also misunderstanding about the instrument called summons. In one of the English cases in regarding Dell, it has been defined as summons is an instrument used to commence a civil action or special proceeding. It is a means of acquiring jurisdiction over a party. The another definition goes like this: summons is an instrument by which a person on whom it is served is asked to appear before the authority specified therein and tender evidence and produce documents or other things. This is the simplest meaning of the term summons. What is the purpose and scope of summons? Question 31 of the FAQ issued by the board in December 2018 says, when can the proper officer issue summons under the Cgst Act? Section 70 answer is, Section 70 gives powers to duly authorized GST officer to call upon a person by issuing a summon to present himself before the officer issuing the summon to either give evidence or produce a document, etc. A summons to produce documents or other things may be for the production of certain document. This part of the answer to the FAQ is directly lifted from section 14 of the Central Excise Act by the board. The important thing is that summons is not a notice. For that matter, every communication or letter coming from the department is not a notice. This is one common misunderstanding under which large number of taxpayers and tax professionals are reeling at present under GST. We tend to declare or consider every single communication coming from the department as a notice. Whether it is a letter seeking the reversal of the ITC, or seeking the payment of some tax dues, audit objections seeking the reversal or payment of the tax or interest, DGGI or any other investigating officer's communication, oral or otherwise, every single communication is being loosely called as a notice. We should come out of this. A notice means a show cause notice under Section 73 or Section 74 of the CGST Act. A summons issued under Section 70, with the initiation of the proceedings thereunder, and the inquiry once completed may culminate into the show cause notice issued under Section 73 or 74. The logical end can be a show cause notice under 73 or 74, but a summons is not a show cause notice. A letter from the officer seeking the payment for any reason of ITC or tax is not a notice. It is merely a demand not preceded or by a notice, and it is not binding legally on the party or the taxpayer. One can always insist upon, and one should always insist upon, the issue of the formal show cause notice. Same goes with the audit objections also, whose objections have not been actually accepted by the party. So therefore, we should come out of this. It's very easy for the taxpayer, and it is natural for our client and taxpayer to consider everything as a notice. So, sir, Atul ji, jaldi aa jaiye na, jara notice aaya hai. And when Mr. Atul Mehta goes there and he sees, he only finds some letter. And for client, everything is a notice. So the distinction between a letter, communication, demand, audit objection, and a show cause notice under 73 or 74 should always be kept in mind. And psychologically, we should come out of this aura of notice. Right? We should stop talking everything in the form of notice. Even a demand is also not a notice, unless it is in the form of a show cause notice. This is one I always wanted to clarify. I always try to insist upon this, because this is leading to a lot of not only misconception, misunderstanding, but even the misguided course of action when we start considering everything as a notice. So summons is not a notice. Summons is really basically an intimation. In a lighter tone, the always an eternal song of Sangam, ये मेरा प्रेम पत्र पढ़कर तुम नाराज ना होना, कि तुम मेरी बंदगी हो, कि तुम मेरी जिंदगी हो. For a tax officer, obviously taxpayer is his jindagi and bandagi. It is a different matter that the taxpayer may not share the same feeling. It's a different matter. So you can call loosely summons a prem patra, whereby a long-lasting, lifelong relationship between the department may commence obviously at the peril of the taxpayer. The second important aspect is, can summons be issued to any person? This is slightly important and sensitive topic, considering in the present scenario where even the professionals are getting caught into this crossfire between the department and the taxpayers. Section 70 of the CGST Act speaks about, I've just read out that, and it says summons to any person. And the word any person is wide enough to cover even the professionals. If an officer making any inquiry against a particular party or a taxpayer in connection with any matter, on any subject matter, considers it necessary to summon his tax advisor, be it chartered accountant or otherwise, the law as such does not debar him from summoning. There has been a recent judgment by Kerala High Court in the case of advocate. Frankly speaking, I still have, whereby an advocate cannot be summoned. I have my reservations about that judgment, but I will only stop by saying that for some reason or other, under the indirect tax, whether it is service tax or GST, we people wearing the black coat have been given a lot of liberties and a lot of relief and relaxation, whether we deserve it or not. So I'll just stop it at that. However, going by the wording of because let us assume there are many tax professionals in the country today who have actually been managing the show of the taxpayer under GST themselves. The taxpayer, his client, does not know anything. right from applying for the GST registration till the filing of the monthly returns, everything is being done by the tax professional. Password and everything is being held by him only. Now, when a particular inquiry is being conducted by the tax officer, and it becomes necessary for him to get the information or explanation or documents, it would be but natural for him to summon the tax professional also. So one should not remain under that impression that a tax professional cannot be summoned by the officer in terms of Section 70. Here, I would also now like to, administer one caution, friends. Things are becoming extremely difficult at the grassroots level, at the ground level. With the daily or hourly basis, the fraud cases are, coming to the surface. I'm not going into the validity of all these claims or whether justifiability of making public all such information on a routinely basis, wide publicity given to it in social media, even by the professional groups. What it leads to, whether it is productive, fruitful or not, it's a different matter altogether. But it's now time for the tax professionals to apply strictly KYC, know your client. Just as it is a time for the taxpayers to also apply KYS, know your supplier. So KYC has now become extremely important for the taxpayers, and it would be in the interest of the tax professional to really, get associated with a client where he is sure about himself and that client also. Otherwise, things can become really, really difficult in a given case when the client ultimately proves to be someone else. This is only a word of caution. I don't want to go into too much detail into this, but apply KYC, please. Coming to who can issue summons. Now we come to the proper officer part. Section 70 says a proper officer can issue summons. Who is proper officer? Proper officer is defined under Section 2, subsection 91. Section 2, subsection 91 defines the term proper officer as mean. A proper officer means a commissioner in relation to any function to be performed under this act, means a commissioner or the officer of the central tax who is assigned that function by the commissioner in the board. Here, I don't know how many of you must have noticed these two phrases which have been used. One is commissioner as defined under Section 2, subsection 24, and another is commissioner in the board. Commissioner in the board is defined under Section 2, subsection 25. And the proper officer definition says proper officer means commissioner or any central tax officer assigned that function by the commissioner in the board. Who is this commissioner in the board? This is the first time this post has been created and given statutory recognition in the history of indirect tax. It is not there even in the customs. So who is this commissioner in the board? Commissioner in the board has been defined by subsection 25 of Section 2 as means the commissioner referred to in Section 168. Now we come to Section 168. What does Section 168 say? Section 168 basically deals with the powers of the board to issue instructions or direction. Subsection 1 basically empowers the board to issue instructions and direction, what we say is the circulars, clarification, etc. for the implementation purpose. And subsection 2 says the commissioner specified in clause 91 of Section 291. Now Section 2 subsection 91 defines proper officer. Proper officer means commissioner, no difficulty in understanding that. But it says, or a central tax officer assigned that function by the commissioner in the board. So for the purpose of subsection 91 of Section 2, for the purpose of designating proper officer, Section 168.2 will come into place, and Section 168.2 says a commissioner for the purpose of Section 2 subsection 91 means a commissioner or a joint secretary posted in the board. It is not your jurisdictional commissioner. Commissioner in the board means a commissioner or a joint secretary posted in the board. If you see, right from the July 2017, the circulars which have been issued by the board have been customarily signed by commissioner into bracket GST. He is a commissioner in the board. Sometimes it has been signed by an officer of the rank of joint secretary. He is commissioner in the board depending upon for what purpose the circular has been issued. So a jurisdictional commissioner and a commissioner in the board are entirely different. So a proper officer for the purpose of section 70 summons is an officer who is assigned that function by the commissioner in the board if he is not the jurisdictional commissioner. And this assignment of the powers has been done by the board by circular dated 5/7/2017. And in that circular, for the purpose of section 70, who has been designated as the officer, proper officer? It is Superintendent of Central Tax. In other words, an inspector cannot issue summons, but a superintendent or any officer in the rank above superintendent, deputy commissioner, assistant commissioner, joint commissioner, or additional commissioner can issue a summons under section 70 subsection 1. He has been designated as proper officer for the purposes of section 70 subsection 1 by the commissioner GST circular dated 5/7/2017. Here, coming to the one question arises, can the superintendent audit issue summons? In my personal view, superintendent audit, or for that matter, deputy commissioner or assistant commissioner audit cannot issue the summons. They are not the designated officers. Audit is an entirely different wing of the jurisdictional commissionerate, and they are not at par with them. Maybe rank-wise is a different matter, but for the purpose of the performance of certain acts under the Act, certain acts under the CGST Act or the rules, superintendent audit, the audit officers are not the same as the jurisdictional authorities which are filled for missing. Therefore, in my personal view, a superintendent audit or deputy commissioner audit or an additional commissioner, assistant commissioner audit, etc., have no power to issue the summons. The circular dated 5/7/2017 has been in the under the firing lines, and I'll come to that later on. So, is a officer of the rank of superintendent and above can issue the summons because he is a proper officer for the purposes of section 70 subsection 1. The subsection 2 of section 70 says that every proceeding inquiry under this section shall be deemed to be judicial proceedings for within the meaning of section 193 and section 228 of the IPC. This is the same. So therefore, you will customarily find that every summons will carry that caption that an inquiry under this summons, proceeding under this summons shall be deemed to be judicial proceeding under section 193 and section 12228 of the IPC. What is section 193 of the IPC? 193 of IPC basically provides for the punishment for giving false evidence. And 228, section 228 of the IPC provides for the obstructing somebody, a public servant sitting in judicial proceeding, intentionally insulting him or interrupting him, and provides for the penal, further action on account of this behavior of the person who has been summoned. So when we talk about any proceeding under summons are to be deemed to be judicial proceeding within the meaning of section 193 and 228 of the IPC, three things emerge. The first is the one is that person is a person who is summoned and who is tendering the evidence cannot give the false evidence. 2, person cannot intentionally insult a public servant, and the officer is being deemed to be a public servant for this matter. And 3, that person cannot obstruct that officer from carrying out his responsibility or duty. Otherwise, in all these cases, a penal action in terms of IPC will lie. And this is to be kept in mind. FAQ at question 32 of the board of December 2018 says, okay, what are the responsibilities of the person so summoned? The answer is, board says, A person who is issued summons is legally bound to attend either in person or by an authorized representative, and he is bound to state the truth before the officer who has issued the summons upon any subject which is the subject matter of examination, and to produce such documents or things as may be required. He is bound to state truth. And there the real, the story, really the drama starts. What if the truth, if stated, implicates or implicates the person or likely to incriminate against that person? If a person says the truth and if he is going to implicate him, because later on that statement of him will be used as an evidence, can he refuse to answer that question? Can he be compelled to say something which will incriminate himself? And here, the Article 20 of Constitution of India will come into play. Article 20 of the Constitution says that a person cannot be compelled to give evidence against himself. Article 20, this is a protective bar. No person can be compelled to give evidence against himself. And in the context of Section 108 of the Customs Act, which is pari material Section 70 of the Cgst Act, there are some interesting decisions of the Supreme Court on this. In NSR Krishna Prasad case, 57 ELT 568, this is the AP High Court judgment. Andhra Pradesh High Court said that administering a caution or warning before recording a statement that the evidence would be used against him, and also that he is not bound to incriminate himself. And if this is not followed, then the statement would not be admissible as evidence. So you would find that whenever a statement is recorded, a customarily officer will write that the person who is that statement is being recorded has been given a caution or warning that that the statement, whatever he is now going to tender, that statement can be used against him. They write it. Nobody bothers to read it. It's a different matter. But absence of such warning or caution will tender that statement inadmissible as evidence, will render that statement inadmissible as evidence. Secondly, that a person need not say something which will incriminate himself. So he can choose to remain silent. This right of the person to remain silent is available to him throughout the entire, at all times during the inquiry by the customs authority in terms of Section 108, as has been laid down in the KK Goenka's case by the Supreme Court. 2 ELT 637, sorry, Calcutta High Court. In KK Goenka case, this right or the protection available under Article 20 of the Constitution of India is available to the person throughout. And that protection is available even under Section 70 of the Cgst Act. So a person can refuse to answer a question if that answer is going to incriminate against him. I mean, if it can be incriminate him. Similar view has been taken by Supreme Court in Hira H. Advani's case, and it was in the context of Section 171A of the Repealed Customs Act, which has now become Customs Act 1962, Section 108. These are all pari material. I am repeatedly saying that the Section 70 of the Cgst Act dealing with the power to summons are pari materia with the other provisions of the Customs Act and Central Excise Act, and therefore all this ratio becomes important. So in the context, in Hira Advani's case, Supreme Court said that it is a 1971 Supreme Court 44, that it does not compel any person to make a statement, but if he makes a statement, he has to state the truth so as to avoid punishment under Section 193 of the IPC. So two parts, which is very important to understand. Whereas one cannot be compelled to say something which will incriminate himself, and the protection available under Article 20 of Constitution of India is available to him. But if he decides to or choose to make a statement, then he cannot make a false statement, because then Section 193 of the IPC will come into play. And this is very important, and this aspect should be kept in mind. In NPR Krishna Prasad case, the failure to administer a caution or warning that the statement will be used against the person as an evidence, it was declared to have rendered the entire statement inadmissible in evidence by the AP High Court. So basically, the right to remain silent is very much available to a person. What happens at the grassroots level, I'll come to. I'm just laid down, mainly trying to explain the basic, certain fundamental aspects and concept of dealing with the summons part. And what will happen, what exactly happened at the grassroots level, we will come to that. Coming to the admissibility of statement as evidence. Customarily, statement is recorded. Statement copy is never given to the party. And then thereafter, when the show cause notice is issued, along with the show cause notice, the statement copy is coming for. Because if it is relied upon, it is a part of the relied upon documents. Whether a statement is admissible as evidence or not. In Ambalal case, Supreme Court said a statement can be used against a person in any legal proceedings. And in this particular case, there was a challenge to, it was a case concerning the FERA, section 40. There was a challenge later on by the person saying that this statement has been recorded under compulsion. After extensively going through the records of the case, the Supreme Court finally came to the conclusion that compulsion cannot be presumed. In this case, the party has failed to provide establish that the statement was recorded under compulsion or coercion or threat, and it was held to be admissible as an evidence. So, unless the compulsion, coercion, inducement, or threat is established, and it can be established by, and the onus will lie on the person alleging so, that his statement was recorded under duress or threat or coercion or inducement, that statement will be binding as an evidence. Again, in Sampath Kumar's case, Supreme Court said that the statement should be voluntary. In one of the celebrity case of K.I. Povani's case, 90 ALT 241, Supreme Court said a person whose statement is recorded after issuance of the summons under investigation is not accused of an offense. In this particular case, there was a challenge to the summons. And in that case, the Supreme Court said that at the stage when a person is actually called for the tendering the evidence and whose attendance is called for by the investigating officer, he cannot be said to be accused of any offense. It is merely he is participating in an inquiry which is being conducted by the officer. It cannot be presumed that he is already being accused of an offense. And that being the case, the challenge to the summons can be an extremely tricky affair. And certain observations made by the Supreme Court in this K.I. Povani's case should be are worth referring to. Going forward, very recently, there is a Delhi High Court judgment of Saurabh Mittal, where the Delhi High Court, it's a 11 February judgment, where High Court refused. It was a case, obviously it's a case of fraudulent availment of ITC, and there were twofold actually relief. One, entire inquiry and the recording of the statement should be undertaken under the CCTV camera and in the presence of the advocate. Both these relief were declined by the High Court in Saurabh Mittal's case. This is the latest judgment, only delivered hardly 15-20 days back. Another aspect is copy of the statement. Can it be demanded as a right? This is a tricky question. Normally what happens? A summons is recorded, summons is issued, person appears himself, statement is recorded, statement copy is never given. There is no law that statement copy cannot be given, should not be given. There is no law that it should be given. The board instruction which is being followed and the practice which is being followed is not to give the statement which is recorded, and it should be given if relied upon only with the show cause notice. Under these circumstances, what a person can do? I generally advise that whomsoever whose statement is recorded, he should do two things. One, there is no harm in putting the request in writing that my statement was actually in response to the summons I had appeared on this and this date at this and this time. My statement was recorded under section 70. However, I have not been given the copy of the statement. Kindly provide me the copy of the statement for my reference and further action as deemed fit. no harm in actually putting this request in writing. Another thing is, on a practical side, a person after leaving the office of the officer actually settle himself, and thereafter he should note down everything what he has said. He need not remember the questions, he need not remember the sequence, but he should remember what he has said. And he should note down everything in a note form in whatever language he is comfortable with, and immediately take it with his legal advisor and bring it to his notice that today what my statement has been recorded, and this should be actually, this is what actually I have stated before him. And depending upon that, after looking into the legal advisor, tax advisor will have to take a call whether any further explanation is required or not, or whether any retraction is required or not. Retraction again is an extremely sensitive business. A retraction cannot be made and kept in the file of the party. A retraction has to be placed on the records of the department, otherwise it has no value. A retraction can be by way of a letter, it can be by way of an affidavit, but it has to be placed on the records of the officer, investigating officer. And it should be a retraction, justifiable, valid retraction, not for the sake of that I retract everything, whatever I have stated. In a given case, one has to muster the courage for the retraction. It becomes at the ground level, it becomes extremely difficult. I know that. Because once the retraction is made and put on the records of the department, officer will again summon that person, again probably do something and force him to retract the retraction by saying that, no, I was wrongly advised by my legal advisor, but I am now retracting the retraction. So but retraction is important. Unfortunately, whatever may be the ground realities, at the higher level, at the tribunal level, high court level, belated retraction is not given any value, is not accorded any value. So everybody knows at the ground level what happens and what is happening. So one has to, if the circumstances demand the retraction, so there are 3 points. 1, statement copy should be officially asked in writing, whatever may be the response. 2, the noting of whatever has been said should be immediately made and brought it to the notice of your legal advisor by the person so that he can take the suitable action. And if any retraction is to be made or any explanation is to be given, then it should be done immediately. These 3 things are important to do. Somebody wanted a citation of the Saurabh Mittal. It is 2022 live law into bracket Delhi, bracket over 163. I think it has since then been probably reported in Taxman, must have been reported in Taxman, and as well as maybe Tax Sutra, Tax India Online also. So the other part is, can the recording of a statement extend beyond sunset or be continuously for day and night? There is one very interesting judgment in the context of income tax. Citation is CCE versus State of Bihar, 2012, 18taxman.com, 70 Patna. I'm not going into the facts of this entire case. This was a case where income tax officers during the course of their search had remained and confined the family members nearly for more than 2 days. They had 2 days and 2 nights, they had actually remained there. And the matter had gone to High Court, and High Court had granted substantial relief in this particular case. As a matter of fact, it is not permissible to record a statement beyond sunset. Yeah, I will be given. I already made it very clear that I will be circulating the PPT in 2-3 days. I will finalize it via CTC. All of you will be getting the PPT. Don't worry about that. So, yeah. So the question here is that beyond sunset, what happens typically? Person is called at 11 o'clock in the morning. He is made to sit at up to 3 o'clock, 4 o'clock, 5 o'clock, 6 o'clock in the evening. After 6 o'clock, 7 o'clock, 8 o'clock in the evening, basically the entire recording of the statement will start. It may continue well beyond midnight also. However, at the end of the statement, the time which is written is always in the statement is the statement commenced at 11 o'clock and was completed at 4 o'clock in the evening or 5 o'clock or 6 o'clock. The actual timings are never actually written there. Now, is this legal and is this permissible? Obviously, the answer is no. Then what is the remedy and why this is happening? You would be all shocked to hear what board has to say in the FAQ on this aspect. In its answer to question number 35, what are the precautions to be observed while issuing summons? In the certain guidelines which are issued by the board in this context, the board says, respect the time of appearance given in the summons. Please mark the word. Respect the time given in the appearance of summons. No person should be made to wait for long hours before his statement is recorded, except when it has been decided very consciously as a matter of strategy. If it is decided as a matter of strategy, what is the matter of strategy? Psychologically break the person. Make him sit till middle of the night and then record his statement. And this matter of strategy, which is supposed to be exceptional, has become a routine practice, as everybody knows. When the board in such a transparent and explicit word gives such a carte blanche, such a green signal to the officers to behave in this manner, one can only imagine that what officers would do. When I went through all this FAQ, I was really shocked. How can a board really say that as a matter of strategy, you need not respect the time given for the appearance? Anyway, but it is within the right of the person to insist upon the actual timing of the statement. One again has to muster the courage for that. If the statement is recorded after 6 o'clock, no problem. Let it be after 6 o'clock. If it is completed at 12 o'clock, 12 midnight, no problem. But it should be insisted upon that you write that my statement commenced at 6 o'clock in the evening and it was completed at 12 o'clock, 12 midnight. They would never write that. And it is a person's right to insist upon that. Again, it's a tug of war. Generally, department wins here because very few people are able to muster the courage for that. But this is very important. One can also, in a given case, suppose the statement is recorded like a post sunset and all, but the time is written wrongly. Then alternatively, one can very next day can send a communication that my statement, unlike what has been stated wrongly in the statement, has actually commenced at this and this hours and got completed in this and this hours. And the proof should be there. So this is very important because it can have a lot of bearing on the very validity of the admissibility of the statement as an evidence. The other important part about whether a lawyer, counsel, or a tax advisor or legal advisor presence can be insisted upon or can be requested by the person who has been summoned. By and large, one of the oldest and the historic judgment on this issue is by the Supreme Court in Pulpandi versus Superintendent 1992 60 ALT. This has subsequently been followed in a number of cases. This will be all my part of my compilation, so I'm not getting into it. Sum and substance of all these judgments and the certain recent judgments in the context of the Supreme Court, I've already referred to Saurabh Mittal, that presence of an advocate or a counsel or a tax advisor is more an exception rather than a right. Wherever such presence has been allowed by the court, they have allowed it in a special circumstances of the case only. One, either because of the physical condition of the person who is under investigation, or because of certain evidences suggesting the unruly behavior of the officers. Only on these cases, which are exception, otherwise this cannot be demanded as a right. And wherever they have permitted it, the advocate has also been asked to sit at a distance. He cannot interfere. He cannot listen to what is being actually asked and what is being replied. He cannot guide his client how to reply. He can sit at a distance and watch the proceedings so that any untoward thing do not happen and the officers really behave themselves. Otherwise, there is no right. Even Kulpandi case, Supreme Court is very clear on this. One cannot demand the presence of an advocate or a tax advisor as a matter of right. Personally speaking, I would personally never even prefer to remain present. I have never remained present as a matter of fact, but in such type of investigation inquiry also. This is something different from the income tax proceeding. I have seen, all of us are aware that when there is a search by the income tax authorities, the first person along with the taxpayer will be the chartered accountant, the tax professional who has been handling his affairs. This is normally either because of the custom, because of the relationship, or otherwise not as a matter of law, as I would say, not as a matter of the right. They remain present. And generally the officer may also probably would prefer the tax professional to be present there because he would be in a better position to explain everything and the control and coordinate the things. However, unlike income tax, indirect tax like GST is a transaction-based tax. Every single transaction carries the rights and obligations with it. As a legal advisor of the company, it would be well nigh impossible for me that in a particular transaction which is under investigation by the officer, what is exactly the factual position? Because I'm not controlling, I'm not coordinating, regulating my clients each and every transaction. He might have actually made a transaction 100 times correctly. Same transaction on 101st occasion, he might have made a blunder. Or there could be some other elements associated with that particular transaction. To put it more bluntly, if the case being investigated by the department is for the issue of the fake invoice without supply of the goods, how can a tax advisor would come to know by simply going through 2A or 2B and the tax invoice is available in the books of with the party, in the possession of the party? How can a tax advisor come to know that whether the goods have physically been supplied or not? There is a tax invoice, there is an e-way bill, there is a payment, there is an accounting in the ledger, everything is there. Does it really signify or certify that the goods have been received by the party? If this is being investigated, would the tax advisor remaining present during the investigation, suppose if he is allowed, is going to do? He can't do anything. It will be very embarrassing in a given case also. So one has to little bit circumspect about seeking the attendance compulsory as a matter of right. Generally, courts are not very much inclined to grant this request. Please keep it in mind. Coming to retraction of the statement, as I said, there are series of judgment on the retraction. Retraction is extremely important. I have just touched upon this aspect. Friends, now let me come to certain practical aspect of it. A revenue officer, while making an inquiry and summoning the person, will have, normally he will apply these four, nitis, as we call it, Sam, Dand, Ved, and Sam, Dam, Dand, and Ved. Sam yani samjana. He will try to explain to the taxpayer, to the person, what can happen, what has happened, what will happen. Like, why are you actually being insistent? Why are you not confessing what you have done? Why do you not, reverse the credit or pay the tax? Otherwise, आपको 100% penalty हो जाएगी, interest आएगा, litigation चलता रहेगा. You will be unnecessarily spending money on the litigation, paying your advocates or your chartered accountants, right? So he will try to explain. That's a soberest part of the investigation. Then dam ki baat aati hai. Pay the revenue to the government. In a given case, pay some revenue as a percentage to me also, depending upon, nature of the case and everything, whatever transpires. Pay the revenue. Their whole concentration is the recovery during investigation. That is their avatar kritya. Recover during investigation. That's all. Once that is done, they know that they believe that their job is done. Their entire job is finished. Because once there is every recovery made under threat is ultimately voluntary payment by the party, because that is what the statement will say. Despite the clear cut, despite number of judgments and umpteen number of judgments and the settled principle of law that no recovery is permissible during investigation. Even if a person is agreeing to the liability on any count during investigation, he accepts his liability, still under law, he cannot be compelled to make that payment unless he decides to make the payment. If he wants to go for the closure of proceedings in terms of section 73 subsection 9 and section 74 subsection 9, he can do that, but it is his prerogative. It is his discretion. He cannot be compelled to do so, even if he accepts the liability. Any amount deposited, paid during recovery or recovered during investigation is in the nature of deposit. There are a number of judgments that if the notice is not issued, if the person has failed to, person has compulsorily paid the money, though on surface it is voluntary, and if he is insisted upon the show cause notice and if it is not issued, then he is entitled for the refund of that money because it is lying as a deposit. Last week only the Cgst in the context of the excise or service tax, the judgment is also come. We don't need judgment on this. The point is this: no authority, there is no authority in the country, including the top people managing the affairs of the Ministry of Finance. No authority in this country can compel a person to make the payment during investigation. Such payment can be enforced only by an issue of the show cause notice, and then show cause notice will take its own course: adjudication, first appeal, second appeal, High Court, Supreme Court. Even show cause notice also does not mean that I have to make the payment. Unless I want to close the case on issue of the receipt of the show cause notice, I can make the payment within 1 month, with or without penalty, depending upon whether it is section 73 or section 74. But recovery during, however, the whole concentration of the officers during investigation, when a person is summoned under section 70, then will be to recover the money, because that makes the task much easier. And here, the first test of the party is resolved to resist such type of compulsion or such type of threat will come into the test. The third is Sam Dam Dand. They will actually threaten the party with the all dire consequences which can happen under the law if he goes on refusing, or if he declines to write what the officers are dictating him. Below hanging till death, every single punishment will be explained to the party. Fortunately or unfortunately, the फांसी की सजा GST में नहीं है. So below that, everything will be talked to him. That आपको ये arrest कर लेंगे, ये हो जाएगा, वो हो जाएगा, like that. And the fourth is Vedniti. Okay, why are you insisting upon? Why are you adamant in what? Why are you not confessing? Why are you not admitting? वहाँ पे आपके buyer ने तो confess कर लिया है कि उनको माल आया ही नहीं, like that. The transporter has confessed that I have never lifted the goods and supplied to the party. Your broker has already said that this was only the bill adjustment. I have never supplied the. I mean, I only brokered the invoice, which itself is the goods in this country. So I have only done that, but the goods were never supplied. When all other parties are actually already admitting, and the similarly placed other people are also admitting in your market, why are you being full and why are you being adamant? So he's a revenue officer. He will apply all these tricks, Sam, Dam, Dand, and Ved. The point here is for the person to take a call what stand he wants to adopt. The other important part is, and you have we are too much under influence or swayed by, we are swayed by their powers and threat. We never get into the limitations of their powers. Their powers are not infinite. They have limitations. So their limitations and your rights should be actually known to everybody. A taxpayer should know what is his right and what are the limitations of the officer's powers. It's not easy, believe me, and I should know it better. It's not easy. We are on this side of the table. But unfortunately, most of the case, majority of the cases, which ultimately goes to the results into so-called notices and demand, they are all messed up during investigation only. And then it is very difficult to salvage those cases at the upper level. Admissibility of statement as an evidence has its limitations, there is no dispute about it. But certain precautions, certain safeguards should be taken, come what may, it should be taken at that stage. Like asking for the copy of the statement, insisting upon the correct writing of the correct time of the statement, then insisting upon what explanations are given, which the officer may not find conducive to his liking, but insisting upon that, or later on put it by way of a letter, retraction by letter or retraction by affidavit, explanation, no money to be paid during investigation under any circumstances, insist upon the so-called notice if in a given case. These are certain, and not getting afraid about their threat which has been customarily doled out of arrest. And normally they are not interested too much into arrest also, because they know that the arrest is the last thing they can do, department can do. And once the person is arrested, ultimately he will be given the bail sooner or later. Then they cannot do anything against that person, because then the person will become absolute. What worst can happen has already happened as far as that person is concerned. Why should he now worry about what the department will do further? And their whole idea is to basically recover money during investigation. And arrest does not help their cause. The point is this, how to deal with this. Investigation requires real-time monitoring, because the bridge is more often than not is burnt behind the party during investigation. There was a question regarding superintendent audit being not proper officer. If you see the July 5/7/2017 circular, whereby the superintendent has been designated arrest. Audit team are. Obviously, they are capitalizing on, they are exploiting the ignorance of the parties. Atul bhai, there is any problem with the linking?
Sir, can you repeat the last 2 minutes? Because their voice was not audible.
Okay, fine. One is superintendent audit is not a proper officer, because July 5, 2017 circular only speaks about the superintendent of central tax as a proper officer for the purposes of section 70 subsection 1. Superintendent audit and your jurisdictional superintendent are not the same authority. Therefore, audit has no power, in my opinion, to issue summons. And what I was mentioning about, that the ignorance about the powers and limitations of the officer has resulted into such a situation that during my recent visit in this week to Ichalpuranji and Kolhapur, I was told that even the audit officers now threatening the arrest, which absolutely absurd and rubbish. Anyway, so this is what the state of affairs is. Admissibility of statement of the co-accused. In a given case, there are co-accused like the transporter, buyer, seller, financier, or broker. A person can always check the cross-examination. I'm not going into the cross. Again, there is some problem. Is there a problem? Can you hear me?
Yes, sir. There was again a disconnection for 10 seconds. So What you can do is sir, you can put off your video. Maybe the bandwidth will increase for the volume.
Okay. Yeah. I'm continuing.
Yes, sir. Yes, sir. Yes.
Okay. Admissibility of co-accused statement, no doubt it can be always, normally they are being relied upon by the department in the proceedings and ultimately culminating into the SOCOS notice. However, it is the right of the party to challenge the veracity of that statement recorded before them. These are all case-to-case basis. Most of the time what happens is the transporter statement is recorded separately. Transporter statement is then shown to the party who is under investigation, say under the case of, in the case of fake credit. And he would say that transporter has already, this is the transporter statement, and he has already said that he has not supplied or lifted the goods at all. What do you have to say? There the person has to be very careful what he is replying to that. These are all, there are no standard rule of it. These are all facts based. There cannot be any set principle of law which can be applied as a common yardstick to all these cases. One has to take a call independently in each and every case. However, having said that, a co-accused statement can always be subjected to put to the test of the his veracity can be tested by seeking the cross-examination. Cross-examination is going to be another vital tool in the defense armory of the taxpayers. It's again an independent, important subject by itself. The cross-examination, one of the most important aspects of the adjudication proceedings. So today I'm not going into that, but even suppose a director statement has gone against the company or a partner statement has gone against the firm, he can be cross-examined on behalf of the firm. As a matter of fact, when a statement is recorded, there is a very recent judgment of the Bombay High Court, which has actually laid down what procedure should be followed. A commissioner adjudicating authority can be asked to really, record the evidence of the person whose statement has been recorded during investigation. It can be insisted upon. And then based on the adjudicating authorities recording the evidence of that party, the person can be cross-examination on behalf of the noticee before that. This is a very interesting and extremely significant judgment. This basically was the law only. For the first time, it has been discussed in such a lucid manner by in a High Court judgment. But again, I'm not going into that because it's again a sort of a topic by itself overall. So therefore, a co-accused statement, even if it is actually used as an evidence against for framing the charges against the main noticee, can always be challenged. Its veracity can always be subjected to the test. Then Section 136, again a very important section. Section 136 of the Cgst Act makes a bold statement that a statement recorded, any statement recorded, and this is where actually a presumption is a presumptive in nature, this particular section, which says that a statement made and signed by a person on appearance in response to any summons issued under Section 70 during the course of any inquiry or proceeding shall be relevant, please mark the word, shall be relevant for the purpose of proving in any prosecution for an offense under this Act the truth of the facts which it contains. When the person who has made the statement is dead or cannot be found. So if the person who has made whose statement is made is dead, or he cannot be found, or is incapable of giving evidence, or is kept out of the way by the adverse party, or whose presence cannot be obtained without an amount of delay or expense, which is unreasonable. In all such cases also, the statement can be used by the department for the purposes of the prosecution of an offense under the Act. And this is sort of a the safeguard measure protecting the revenue action in a way. Because if the person who has made the statement is dead, still his statement can be used as an evidence. But for the purposes of proving in any prosecution for an offense under the Act, the powers are actually restricted in my opinion. It cannot be customarily used. If the person is dead who has made the statement, and if his statement is going to be used against the party in raising the demand for on any count whatsoever, in my opinion, the protection given to the revenue action under this case cannot be made applicable. Then there are certain other aspects of the summons proceedings. How to deal with the summons? Let me now come to the brass tacks. When a summons is issued, first of all, one should not get frightened. Summons is not a notice. Summons does not mean it is like an arrest memo. A summons is merely an intimation calling the party to appear before the investigating officer if he is being called, and also to tender evidence and to give the information or produce the records or documents. Summons purpose is very, very limited. It can be issued to any person. If the summons is actually, when it is received, the first thing is whether summons should customarily carry the DIN or not. And if the DIN is not there, whether the summons will become invalid. No doubt, the board circular and the board instruction very clearly that any communication from the department should now, Cgst officers should carry the DIN. State government officers are not following this because they have not gone by this type of circular at all. So if the DIN is not mentioned, board circular says that the communication will be invalid. There are two aspects flowing from this entire thing. If the DIN is not mentioned on the summons, his validity, even if it is challenged, you will have to challenge it before the High Court only. Will it be worth? In my opinion, no. High Court is most likely to treat it as a technical lapse. No doubt, Section 168, subsection 1, under which board is empowered to issue clarifications or instructions for the implementation of the provisions of the Act. It is binding on the department at all levels across the country. And therefore, if the board says any communication without DIN is an invalid document, will equally be applicable. Still, whether merely because of that reason, whether the summons will become invalid. And even if it is challenged, what will happen? Okay, that particular summons will become invalid. Nothing stops from the investigating officer to issue another summons with a proper DIN. So what can be done is, instead of that, the objection can be put into the writing, even while responding to the summons, that this summons does not carry the mandatory DIN as actually as per the instruction, in terms of the instruction issued by the board, wide circular number so and so, so and so, so and so. This should be, objection should be put into writing. Instead of making a great show over it or making a hue and cry over it, and not to go to the High Court, in my opinion, it will be clearly waste of time, money, and energy. That goes as far as the DIN is concerned. The other part is what to do about that. Generally, the summons are given at a very short notice. They are being actually, sometimes it is given, they come, they hand over the summons, there and then only. This practice can be objected to. If in a given day, suppose the person is called after 7 days or 2 days or 5 days, but with lots of information, then it is right of the party to seek the time. No harm, but one should never ignore the summons. One should never get frightened of the summons. One should not feel the compulsion of attending at the given day and time when the summons is issued. It is always permissible for the party to seek another date and time or seek some more time for furnishing the information. But it should be responded. Non-response to the summons can be dangerous. And this is very clearly established in the case of Ankit Bhutani versus Union of India, 2020-35 GSTL 71 Allahabad. Party has been actually ignoring and was evasive about the responding to the summons, and finally it challenged the validity of the summons and the action thereunder before the High Court. High Court came down very heavily on the petitioner after looking into the records of the case. So one should never ignore the summons, but one should never get frightened of the summons. It is your right to ask for the further time, for appearance also, and for furnishing the information also. That brings to another question, that any information, anything which is given to the investigating officer should always be in writing. It is again the right of the taxpayer to insist everything into black and white. Whatever they may demand, the demand may come independent of summons, because everything is now getting talked over the phone. The continuous love talk goes on between the taxpayer and the officers or the tax advisor, I'm sorry to say, tax professional and advisor, and the departmental officer. This is one practice which one should really, really seriously think how far it is healthy and how far it is advisable. Talking on the phone, receiving the phone, explaining everything on the phone, ji hajur, one has to come out of this mentality. I'm not talking about, taking up the fight with the officer every now and then. Maintaining the cordial political, polite relationship is one thing, and every time trying to have that submissive attitude, surrendering attitude, and keep them in the good mood attitude is not really going to help the cause of the justice nor the cause of the taxpayer client. One should very clearly say, whatever information is required, please put it into black and white. This is more so if the entity involved is a corporate entity. One can always say that I have to put up this before my management. I cannot simply say. In a given case, suppose if any information is being provided in black and white, writing, subject to their telephonic requirement, then put it, please refer to your telephonic instruction or telephonic verbal instruction. Put it like that. In response to that, I am submitting this information in writing. One should always have the identical set of whatever is given to the department. And this is not only for the investigating officer under summons. Even in a given case, whatever information you are giving to any authority, audit, jurisdictional authority, anti-evasion, preventive, DGGI, or whomsoever, one should always have the identical set of papers, whatever is given, unless it is too voluminous. But what has been given should be always available by way of a record, because ultimately they will become relevant for the purpose of the defense when the show cause notice is issued. These are certain ground level rules which are required to be followed. Insist upon, take the time with the information, but don't delay. Don't delay. आज की मौत कल करने से कोई फायदा नहीं होता है. So if you have information ready, then give it the information. If the information compilation will take some time, but some information is ready, give some information. For the rest, you seek the time. These are all your prerogative. This should always be done. Can one challenge the summons? One can always challenge anything under the. Ultimately, we are dealing with the statutory provisions. But how far it is advisable to challenge the summons? There are a number of cases. Again, it will be part of my compilation. The summons substance is this: unless there is a sheer abuse of powers, court will not be inclined to entertain or intervene during the investigation and post the summons proceedings. People have been at a very, very wrong end of the, stick when they have been bold and adventurous enough to challenge the summons. So a challenge to summons is not really advisable. Here, I will just point out one interesting development. 57/2070 is the board circular, and there is a notification also. In the context of Section 70 and DGGI powers, personally, it has been always my view, and obviously these are the views said by certain seniors also, and this is that whether DGGI has got power to undertake the investigation and issue summons. We have always been of the view that DGGI has no powers. DGGI, which was erstwhile DGCEI, Director General of Central Excise Intelligence. DGGI has no powers. The board notification investing them with the powers, DGGI, and their investigation powers to issue summons under Section 70 are subject matter are susceptible to serious legal challenge. This challenge has already been mounted. Very recently, in Mohit Kirana Stores case, Rajasthan High Court has issued the notice in this case. And no doubt there are two parts. One is challenge to the DGGI powers to undertake the investigation. And the second one was summons was issued after the adjudication was over. And court was probably guided more by the second aspect. Canon India DRI judgment was also relied upon. Last month, Goa bench of the Bombay High Court in Provident Housing Limited case. The fourfold challenge before the High Court in this case is the board notification is empowering the DGGI to undertake all India investigation on all India basis, So like Mumbai DGGI officer investigating matter in Kerala. Everybody says that DGGI has got all India powers. So these powers are under challenge. Second is there, as a corollary, their power to issue summons under Section 70. 3, recovery during investigation. And 4, refund of the money which is recovered during investigation. All these aspects are now subject matter of the consideration in this petition before the Goa bench of the Bombay High Court in Provident Housing Limited case. Very significantly, High Court has issued the notice and directed the department to file the counter. And in the meantime, the government counsel has given an open assurance in the court saying that till the time the writ petition is disposed of, no recovery or coercive action will be undertaken against the party. This case is probably going via Canon India case. Canon India is now under review before the larger bench. We'll have to just wait with the bated breath what happens to that. But independently of that, a view can be taken that DGGI has no power to undertake any investigation. And the notification empowering them can be subject matter of a serious challenge. And this is all. The 1st July 2017 notification is also under challenge before the Rajasthan High Court. Similar challenge has been mounted in this High Court, and there are a couple of other writ petitions in a different High Court also. The other important aspect is about the dual or simultaneous investigation. The simultaneous investigation, there is another headache and heartburn facing the taxpayers. Where can it be undertaken? Section 66, subsection 2, clause B, which comes into play here. What does it say? Section 6 says that where a proper officer under the State GST Act or the Union Territory GST Act has initiated any proceeding, on a subject matter, no proceeding shall be initiated by the proper officer under this act, that is Cgst. Now, 6.2b speaks about state government or Union Territory GST officer having initiated the proceeding, debarring the central GST officer to undertake the proceeding on the same subject matter. However, Board Circular of 2018, 510-2018 speaks about both. If the CGST officer has initiated the proceeding, state government officer should not undertake, and vice versa. And board has also stated that the authority which has initiated the proceeding should only end the proceeding and take the necessary action. Final action should be taken by the authority initiating the proceeding on the same subject matter. Now, this particular provision has been subject matter of challenge before the High Courts in many cases. In Bhavani Textile case, Gujarat High Court, there was an investigation by Ahmedabad Zonal Unit of the DGGI. However, simultaneously, there was a summons issued by the State GST Authority and also by the Surat Regional Unit of the DGGI. Ahmedabad Zonal Unit DGGI was already investigating the matter. There was a simultaneous summons by state government officers as well as the Surat Zonal Unit of the DGGI. High Court said that this is contrary to the instruction issued by the board after taking note of that all the authorities were investigating the same subject matter, and the entire summons issued by the proceeding initiated by the inquiry initiated by the state government officer and Surat Zonal Unit was quashed by the High Court in Bhavani Textile case. In Kaushal Kumar Misra's case, the Punjab and Haryana High Court, there was a challenge to the summons by the two authorities, but this petition, the challenge was dismissed by the High Court, noting that the subject matter which was under investigation by two authorities who were simultaneously investigating the matter was entirely different. If the subject matter was different, then nothing precludes from two authorities to undertake this simultaneous investigation. With these observations, High Court dismissed the petition. In Sonam Barlia case, Odisha High Court judgment, the proceedings by state government were quashed because High Court found that the central government authority was already seized of the matter and the subject matter was the same. And in spite of having state government authorities were informed that the CGST officers are already looking into this matter, investigating the matter, still they continued with their inquiry and investigation, which was caused by the High Court in the Sonam Barlia case. Again, in Coupon Counter case and Siddhi Vinayak trading case also, Allahabad High Court and Madras High Court, both of them have dismissed the petition because the subject matter were different. In a very important judgment of GK trading case, Allahabad High Court has actually explained the term inquiry and proceeding. Friend, this is very interesting and important. Section 70 dealing with the summons uses the word inquiry, whereas Section 62B says initiation of the proceedings. The Honorable Allahabad High Court in GK Trading says that the inquiry is not the initiation of the proceedings. It is the assessment, determination of liability, show cause notice, which will only come under the proceeding under Section 73 or 74. But inquiry is not a proceeding. Inquiry is not an initiation of the proceeding. I have personal reservations about these observations of the Honorable High Court. Honorable High Court has also explained what is the subject matter or on the same subject matter. That phrase has also been explained in this judgment of GK Trading Company. Okay, what is meant by the on the same subject matter? High Court says same subject matter means same cause of action for same dispute involved in a proceeding before both the authorities. With all these observations, the High Court in GK Trading case actually dismissed the petition challenging the summons inquiry. And another sterling judgment, it went against the taxpayer, Gujarat High Court, Yasho Industries Limited. The challenge to summons under Section 70 dismissed. This is a judgment which requires a careful consideration because many aspects in this case were not really probably brought to the notice of the Honorable Court. But otherwise, the power of the officers to issue the summons and undertake the inquiry, DGGI, which was under challenge in Yasho Industries case in Gujarat High Court, the same remained subject matter of challenge. Somehow other, Yasho Industries went on a different track altogether, and the challenge has been dismissed. So, but the challenge is still open. So these are, then there are a few more judgments on this overlapping of the jurisdiction. The point is this, that so long as it is the same subject matter, which has already, for which the inquiry has already been initiated by the particular officer, whether state government or by the central government, then definitely going by the words of Section 62B and the board circular of October 2018, the other authority cannot again poke his nose into that and also start the simultaneous inquiry or investigation on the same subject matter. These are, and if that is happening, it would be probably, this objection first would be put into black and white to the respective authority to whomsoever, and then thereafter, if they still insist and continue with the inquiry, then it can be subject matter of challenge before the High Court. Coming to the other part about the inspection, search and seizure, I will, certain important aspects of this entire activity, I will just point out. Section 67 is the one comprehensive, self-sufficient piece of legislation dealing with inspection, search and seizure. It is a self-sufficient, complete code as far as this subject matter is concerned. Under Section 67(1), a proper officer, not below the rank of Joint Commissioner, can undertake the search in certain activities. Subsection 1 speaks about Clause A speaks about the activities. Clause B speaks about the persons, transporter, owner of warehouse, etc. So it is in two parts. However, such search or inspection can be undertaken by the proper officer, not below the rank of Joint Commissioner, only if he has a reason to believe, okay, that some documents or things have been secreted, and there is a likelihood of the offense or evasion of tax under the Act, likelihood of offense or breach of the provisions of the Act. The word used in Section 67(1) is a proper officer. It says a proper officer not below the rank of Joint Commissioner. We have seen that the proper officer is defined under Section 2, subsection 91 as a commissioner or any officer appointed by the commissioner in the board. Now, commissioner directing the inspection and search under Section 67 is not difficult to understand, but not below the rank of Joint Commissioner. A Joint Commissioner is not a commissioner. So therefore, Joint Commissioner has to be, or any other officer below him, like Deputy Commissioner or the Additional Commissioner or Assistant Commissioner, that officer has to be empowered for this purpose by the circular, by the Commissioner in the board under Section 168(2). If that empowerment is not there, then the very initiation of the inspection or search action can be subject matter of a challenge. This is number one. Secondly, the section says A proper officer not below the rank of joint officer can undertake this inspection and may authorize an officer if the joint commissioner or additional commissioner or any other officer below commissioner himself is delegated this power assigned. Can he further delegate to any other officer? Like if the joint commissioner as a delegate of the powers is undertaking the inspection or search, can he delegate to the superintendent or assistant commissioner? This can be a subject matter of serious challenge again. Can a delegate can further delegate? One has to get into this. Subject to this, on the jurisdictional aspect, such powers can be exercised when there is a reason to believe. The word used are reasons to believe. Okay, something is secreted and there is a likelihood of the offense. The word reason to believe have been explained by the Supreme Court in Shiona Singh versus Appellate Assistant Commissioner of Income Tax, All India Report of 1971. That means that the belief must be that of an honest and reasonable person based upon reasonable grounds. Reason to believe means it is that belief which is of an honest and reasonable person based on the reasonable grounds. In State of Gujarat versus Mohanlal Jitamalji Porwal, Supreme Court said, AIR 1987, that on the aspect of the existence of relief, there are sterling and some revealing observations by the Supreme Court in this case, that on the aspect of the existence of reason to believe, court are not expected to sit in the appeal. They are not supposed to put the issue of existence of reasonable belief under legal microscope. They are not supposed to look at it with an overindulgent eye, which sees no evil anywhere within the range of the eyesight. They have to, the circumstances have to be viewed from the experienced eye of an officer who is well equipped to interpret the suspicious circumstances so as to form a reasonable belief. So Supreme Court basically frowned upon the court sitting over the issue of whether there is a reasonable belief or not. In this Mohanlal Jitamalji case, Section 26 of the Indian Penal Code says a person is said to have a reasonable reason to believe a thing if he has sufficient cause to believe that thing but not otherwise. A person is said to have a reason to believe a thing if he has sufficient cause to believe that thing but not otherwise. However, a reasonable belief cannot be based on the assumption, presumptions, surmises, conjectures, apprehension, or suspicion. Howsoever strong the suspicion may be, a reasonable belief cannot be based on mere doubt or suspicion. There is a difference between reason to believe and reason to doubt. Supreme Court in Century Recycling Metal Recycling Private Limited case 367 ELT 3, Supreme Court said, reason to believe or satisfaction are positive terms which require reference to facts and figures to show existence of positive belief, as opposed to reason to doubt, which requires only an uncertainty reflecting apprehension or suspicion. Merely based on the apprehension or suspicion about the likelihood of the offense or evasion, the action under Section 67 cannot be undertaken. In Gopaldas Uddhavjai Ahuja case, Supreme Court said, propriety of belief or sufficiency of material is irrelevant. Propriety of the material belief or sufficiency of the material is irrelevant, but some material should have existed on which belief can be formed. In another very important, interesting judgment of income tax by Supreme Court in Union of India versus Agarwal Iron Industries, 2014-310 ALT, Supreme Court said, search and seizure under Section 132(1) of the Act. I am sure Honorable Sri Taneja Sir must have dealt with this aspect also. That search and seizure under Section 132(1) of the IT Act, reasons are required to be recorded in file, and the same can be scrutinized by the court as to whether the authority has appropriately recorded the reasons for forming an opinion. While those reasons need not be required to be communicated to the party, but the reasons should be there on the file. And in a given case, the court intervention can be sought for whether there are proper reasons are recorded in the file so as to form a reasonable belief about the action proposed to be undertaken. These principles will be squarely be applicable while dealing or while considering the validity of the action under Section 67 of inspection, search, etc. Section 67(2) speaks about search and seizure of goods, documents, or books or things. That if there is a reason to believe on part of the officer undertaking the inspection, and he is of the opinion it is necessary for the purpose of further examination and the proceeding under the Act, he can actually he can seize the material goods that is goods, documents, or books or things. Now, provided he finds its usefulness or the relevance to the proceedings under the Act. One question can arise is whether money, cash, can be put under seizure during investigation and search. Whether money can come under the definition of goods or things. In Kanishka Matta's case, Madhya Pradesh High Court recently, 2020-42 GSTL 52, in this case, High Court upheld the seizure of the case found from the premises which were being inspected and searched by the officers under GST. Generally, the case can become subject matter under indirect tax law like excise. We have come across such cases where the reason to believe is that this case is the sale proceeds of the illegal sale proceeds of any clandestine activity, like sale of the goods in a clandestine manner without payment of tax. Simpliciter case which are found while something being investigated, can it be subject matter of a seizure? I have my reservations. But going by the the epistemology and what money is, what is the meaning of money, whether money comes under the goods or things. Yes, there are definitions, there are English court judgment which says money comes under the definition of goods, or some judgments say it comes under things. So strictly, theoretically and literal meaning, money can be subject matter. But what are the circumstances? What could be the basis on which money found in cash in the premises can be subject matter of a seizure? Like in a Kanpur recently, the 200 crores which have been seized, unless and until there is a reason to believe that these are illegal sale proceeds of any clandestinely or of any clandestine activity in breach of the provisions of the law, can it be subject matter of seizure? This is something probably may become a subject matter of challenge in the coming days. The first proviso to section 67(2) says that if it is impractical to seize the goods because of its very nature of the goods or the volume or for any nature, then what procedure should be followed? Generally, it is we call it as a supratnama. That supratnama will be prepared. Goods will be the person from whose premises the goods have been seized become the custodian of the goods. He cannot tamper with part with the goods without the permission of the authority. He becomes merely the custodian of the goods. He is given the supratnama. Second proviso to section 67(2) says retention of seized documents or books or things for so long as may be necessary for examination or inquiry or proceeding under the Act. There is no time limit for which the documents or seized documents or books or things can be kept by the investigating officer once they are seized, once they are put under seizure. There is no time limit. They can keep it so long as it becomes useful. They consider it useful for their inquiry and examination. The section 67(3) says return of the seized document, books or things within 30 days of the issue of the notice. Then comes subsection 3. Any books, document, I'm not talking about the goods, sir. Please mind you. I'm not talking about seized goods. I am talking about seized documents, books or things. Any seized documents or books, etc., which are seized during the course of inspection investigation, once the show cause notice is issued, then within 30 days, whichever have not been relied upon have to be returned to the party. So when a show cause notice comes, the first thing to look into is the annexure called RUD, that is relied upon document. Normally there will be relied upon documents annexure. These documents are required to be or are supposed to be there along with the show cause notice. And along with the show cause notice, if they are not there, first thing is to ask for the copy of that. And based on the Panchnama, which was done at the time of investigation and the seizure of documents, the documents which have been taken over by the department, records, one has to compare under Panchnama what documents they have taken, out of which have been relied upon in the show cause notice. Relied upon documents, copies will be given, originals will never be given, and which are not relied upon but lying in the custody of the department, possession of the department, they have to be written by the department themselves within 30 days. In any case, it is the party's right to ask for the return of the originals, which are not relied upon and lying in the custody of the department. Section 67(3) takes care of this matter. Section 67(5) allows the person to obtain the copies or the excerpts of the documents which are seized and lying in the custody of the department. As I said, that because during investigation also this right can be exercised. Because so-called notice may come at a later point of time, nobody knows at what point of time. But however, the documents and the records which are in the possession of the department may be required, say, for finalization of accounts, filing the IT return, tax audit purpose, for whatever purpose, it is the right of the party to seek the copies thereof or at their own cost or for the excerpts of that. And this right can be exercised even during investigation. And finally, about the goods which are seized by the department, and Section 67 subsection 6 speaks about the provisional release of the goods on execution of bond and furnishing of security. There are guidelines laid down by the board. What should be the quantum of security? What should be the nature of the security? Bond is on 100 rupees paper. And payment of, or otherwise on the payment of tax, interest, penalty, etc. Depending upon the facts of the case. But it need not be always on the basis of the payment of tax interest. It can be without payment of tax, merely on bond, on execution of bond and furnishing security. This is the provisional release of the goods. And if from the date of seizure, if within 6 months the notice is not issued, this notice can be independent of the demand of tax. This notice can be, if the seizure is continued to be dealt with and proceeded with, then they become liable for confiscation. Seizure is the first step before confiscation is undertaken. So then there has to be notice why these goods should not be now held to be liable for confiscation and why the fine should not be imposed, whatever redemption fine, because absolute confiscation is not provided under the law, unlike customs in certain cases. So therefore, such notice has to be issued. It need not be a demand notice for the tax. That investigation can continue. But from the date of seizure of the goods, if within 6 months the notice is not issued, then those goods have to be compulsorily returned to the party. Section 67(6) says so. And there is these are all actually, these are age-old provision. These are there in custom. These are there in excise also. Where there in excise. However, there is a power given in the first proviso to the authority commissioner for extension of the period by another 6 months. Beyond that, it cannot do. So at worst case scenario, goods can lie within the custody of the department under seizure without notice for maximum 1 year. A question may arise whether after 6 months, when the extension is to be accorded by the commissioner, then whether that principles of natural justice are required to be followed, whether parties should be given an intimation that it is proposed to extend the period by another 6 months. In my opinion, yes. Though law does not say so, because it is detrimental, prejudicial to the interest of the party of extension of the period of seizure. And therefore, it has to be followed. If it is not followed, it can again be a subject matter of challenge. Another thing is, here also while granting the extension, the officer, that is jurisdictional commissioner, has to have a reasonable ground to grant the extension. Whether there existed a reasonable ground for the granting the extension of the period of seizure, he has to record it in the file. And this can definitely be subject matter of scrutiny by the High Court, where they can get into, there is a judgment of the Supreme Court in one of the famous judgment on this aspect about extension and the release of the goods when the notice is not issued is the very, very important judgment of the Supreme Court in the I.J. Rao's case, which is one of the celebrity cases on this aspect. The Supreme Court in I.J. Rao versus Assistant Collector of Customs versus I.J. Rao versus Vibhuti Bhushan Bagh, and this is 42 LT 338. And in a beauty gem case, Bombay High Court has said in 2018 359 ELT, in beauty gem case, Bombay High Court said the extension of seizure can be undertaken only if there is sufficient cause and it must be supported by reasons. It was further held that where the time period was extended without showing cause, the order of extension was not valid. So these are the principles which need to be followed. And finally, Section 83, provisional attachment of the movable or immovable property, including the bank account. That Section 83 says that whenever there is an initiation of the proceeding, during the pendency of the proceeding under Section 62, 63, 67, 73, 74. So when inspection, search and seizure has been undergoing under Section 67, it gave the power to the commissioner under Section 83 to protect or safeguard the revenue interest to resort to the attachment of the movable, immovable property, including the bank account. And we know that the attachment of the bank account is rampantly happening nowadays. This has been subject matter of challenge before number of cases by the High Court. Two things only I will observe because I'm already the time is over. I would not like to stay too much. So two things. One, bank account can be subjected to attachment not without putting the party on notice, because they directly write to the bank and stop them, ask them to direct them to do, stop the all transaction in that. It is an attachment of the bank account. Secondly, it can be attached only of the taxable person against whom the inquiry, like section 67 action is there or section 73 show cause notice is there, etc. It cannot be again any other person or the family member of the accused. It cannot be of the cash credit account under any circumstances. There are now number of judgments on this. It cannot be of the cash credit account where the hypothecation facility is being availed. Then, so there are certain principles which have been laid down recently in various High Court judgments. However, in spite of all this, two important judgments which are required to be kept in mind is of the Valerius Industries Gujarat High Court judgment and Supreme Court Radhakishan Industries judgment. They have made certain very, very significant observations on the abuse of powers under Section 83 of the attachment on the basis of the pendency of the proceeding under Section 67, like inspection, search, seizure, or issue of the show cause notice issued under 73 or 74. However, these have all appear to have been ignored by the authorities, and it appears lawmakers have now, by Finance Act 2021, frighteningly, very, very seriously expanded the scope of Section 83 by referring it to Chapter 14, 15, 17. There are a number of provisions which are where the very initiation of the proceeding will allow the commissioner to resort to the attachment for safeguarding, for the so-called safeguarding the revenue. Up till now, this provision amendment which have been made by Finance Act 2021 have been made effective from 1st January 2022. They have already been made effective. And the words used are till 31st December 2021, Section 83 spoke about during the pendency of the proceeding, and now it is on initiation of the proceeding. One example is enough. Chapter 14, which covers Section 67, 78, 68, 79, 69, 70. 70 is a power to summon. 67 is inspection, search and seizure, initiation of the proceeding of inspection. On the very initiation of the proceeding, very issue of the summons under Section 70, the commissioner can probably resort to the attachment on a purely literal interpretation of the provision. Here, summons is issued, and the jurisdictional commissioner may resort to the attachment of the bank account or the movable property. Such power, I am sure, these powers and this provision again will not stand the scrutiny of the law. They are highly excessive, arbitrary, unreasonable, and against all norms of justice and the principles of natural justice. They are unconstitutional. Directly, the attacking the power rights under Article 14 and 19(1)(g). So we'll have to see the challenge on that. But this is recently January 1st. This expanded version of Section 83, the widening of the powers under Section 83 has now become the reality. So one has to be careful on this aspect. So friends, these are the overall, the entire Section 70 summons, search, seizure, and inspection. It has to be looked at it from a certain very, very pragmatic and practical way. Legal aspect, fundamental aspects governing this, and the principles of law which have for ages governed this type of inquiry and investigation, because these are not new provisions. I will only say this. Unfortunately, what is happening is we are dealing with and looking at the GST law as if it is an alien piece of legislation, as if somebody from the Mars or Saturn or Uranus have come and actually imposed this law on us. The fundamental concepts of the laws are the same as they were in excise and service tax, in VAT, and now even under Customs Act also presently. I mean, these are fundamental concepts are not new. There are some changes, there are some additions, but otherwise fundamental concepts are the same. Taxpayer is the same. Tax professional is the same. Eyes are the same. Eyesight is the same. Spectacle is the same. Spectacle, glass size and everything is the same. Only we try to wear the new color every time. when we approach the law. And we find the world entirely new, as if we are dealing with something new situation while dealing with the GST law. Some internal, soul searching is required. Okay, are we really on the right path? And are we really dealing with the law in the manner in which we are expected to deal with this law? Or every time, why are we approaching this law with as if something new is coming to us and hitting us, and we are actually groping in the dark? There is no need to. There is enough material available, enough principles of law available, provisions of law available in the erstwhile law and the judicial principle, which are there to guide us. They will serve as a guiding searchlight in this dealing with this law. Thank you. Thank you very much for the present hearing.
Thank you, Shailesh bhai. It was nice presentation on GST Seizure. Thank you for that. Also, so you have given many citations. So your analysis backed by many citations is actually is like a icing on the cake, sir. We thank you for the same, and now I request Sumit to propose a well-deserved vote of thanks.
Thank you, Atul bhai, for the opportunity to present this wonderful and very well-deserved vote of thanks to our faculty for today, Shailesh Sheth, sir. Since we almost agree, sir has not only just taken the painstaking effort to guide us through all these issues and the way forward for search and seizure investigation, all these things, but he has shared with us his on-hand practical knowledge, coupled with the various judgments for the reference material, and guide us as the practical way through what we should expect, what we can do, where we should fear, where we should not fear the department and the legislature, everything. Hence, I think this effort, this tremendous effort by Shailesh Sheth deserves a very well-deserved round of applause. Thank you, sir, for sharing your knowledge and expertise with us on this forum. As always, we are and will always be grateful to you. Thank you.
Thank you, Shailesh bhai.
Thank you very much.
Hello.
Yeah, Shailesh bhai, can you hear us?
Yeah, we can.
Yeah, so I think there was some technological issue, but we are really thankful to you, Shailesh bhai, for a masterly analysis as always. Thank you so much, sir.
Thank you very much.
Thank you to all. Thank you to participants as well for making this program a success. Thank you.
Thank you all. Yes.
Dinesh bhai, end karo session?
Yeah.
Okay. Thank you.